Court. Appellate. For the record, Andrea Cannell on behalf of the appellants. Would your honors like a brief recitation of the facts?
I think you can assume we've familiarized ourselves with the facts and read the briefs, so get right into the issues if you like.
Thank you. With respect to my time, may I have 15 minutes reserving 5?
Yes.
This issue before this court and what was the issue before the trial court was a narrow issue. It was a contractual question. And it was a contractual question regarding a commercial real estate transaction. And what happened is that the trial court applied the law and applied the duties and applied the standards that govern a residential real estate transaction. And had the trial court applied the correct standards, then it would not have come to this erroneous verdict and would not have denied the appellant's motion for a directed verdict. Now, where the trial court should have found guidance onto what is a residential transaction or residential real estate and that which is commercial real estate is in Florida statute. In Florida statute 475-701 excludes certain properties as residential real estate. And there in that definition, the parcels in question here fall under the statutory definition.
This was vacant land, wasn't it?
Yeah, it's a commercial real estate.
It was vacant land.
Right, so then the doctrine of caveat emptor applied. The appellants had no duty to disclose any issues regarding the property. In addition to that, that the doctrine of caveat emptor applies when a purchaser of vacant land is entering into the transaction. The case law says that they should inspect the property. They have a duty to inspect the property because they're buying vacant land. And the Florida Supreme Court already answered a similar issue in the Conklin case where it refused to extend the protections in Gable, which are consumer protections to residential transfers of land. So this contract was a written contract that was drafted by the appellee and his agents.
Well, let me ask you this about the contract. You've got this provision for the feasibility study, and at the end of the 30 days, you send notice, I don't like it, I want my deposit back, or you buy it, and you buy it as is. And then you've got this handwritten additional term that has this representation, I'll call it for want of a better term, that it can be subdivided into 8 lots per plot, 16 lots total. So should we interpret that, is that an independent warranty that survives the closing, or is that part of the things that the buyer is supposed to investigate during the 30 days for the feasibility study?
Those terms work in conjunction with one another. The testimony at trial said it was their intended purpose to divide the property. The feasibility study states that you're supposed to investigate the property, whether it be through zoning, surveys, engineering, anything you like, including subdivision of the property, to see if that property is suitable for your intended use. So I would submit to the court that those handwritten terms were drafted by the appellee and probably were their intended use. Thus, they had a duty during that 30-day to go down to either, well, according to the testimony in the record, you could pick up the phone and call the Charlotte County planner's office, and they would tell you how many lots would fit on an acreage of property. But they did nothing. They actually hired a company during the feasibility study to look for birds and to look for turtles. But they did nothing to see if the property met its intended use. And I would say, to answer your question, they worked together. Those were their intended use. One doesn't trump the inclusion of those terms did not disregard the feasibility study. During the feasibility study, appellee should have exercised his right to make sure that that property fit his intended use, contained there in those handwritten terms. And if they did not notify the seller, and he would have been given back his deposit question-free. He didn't, and he accepted the property as is.
let me ask you this. The trial judge found that, I guess he found that there was a breach of contract and also found that there was a negligent misrepresentation. But there's nothing in the final judgment that talks about justifiable reliance. What is the impact of that? Or should we assume that the trial judge, based on his verdict or final judgment, found justifiable reliance by the buyers on the handwritten terms in the contract?
That was raised in my brief, is that I don't believe justifiable reliance was ever addressed. And because the trial court needed to take into consideration, one was the playing field of the parties, and Conklin addresses that too, where investors have a higher position at the bargaining table than do the individual homeowner that's going to buy their first piece of property. So the justifiable reliance was not addressed by the trial court, and some of the factors that should have been considered by the trial court should have been that they were both experienced real estate agents. The appellee was represented by a real estate agent in the transaction. He had an opportunity to inspect the property. They were the ones that made the offer and reached out for the property. They were not pursued. And which also goes to misrepresentation. The court.
I guess, I understand the arguments that, that would go, that you would make that there wasn't justifiable reliance, but now that the trial judge has made his decision on this, so if it doesn't specifically, the final judgment doesn't specifically address the issue of justifiable reliance, are we to assume that the judge considered this, or was it raised in your motion for new trial?
It was raised in the motion for new trial, and it was raised in the appellant's motion for directed verdict, and the trial court left it out of its final order. And if it's missing from the final order, then it means it was not adjudicated, and that is a necessary element for misrepresentation, a negligent misrepresentation.
How about on the breach of contract count, which he also found in their favor on?
Well, again, the trial court was applying a residential standard, and the cases argued to him at the trial level were all residential cases where there is no buyer beware, there is no acceptance of the property as is. So that is a distinction, and that is an error. But in addition, for negligent misrepresentation, the courts look to see if there's been some trick, some artifact, some area where the seller tries to prevent the buyer from inspecting the property, or not give the buyer an opportunity to inspect the property, and therefore they take the property with these errors or defects, or it doesn't meet their desire. But the contrary is in this case, is that the appellee and appellants contracted to allow the appellee a month to go do whatever it is that he wanted to that property to see if it fit his intended use.
And if it's your question then, if looking at the contract itself, you'd agree that the contract does say that the handwritten terms will control over any pre-printed. Okay, that's in the contract itself, correct?
Correct.
And I believe what the trial court did, he recognized that, and then you have this handwritten term, and what does that mean? Parcels must have the ability to be subdivided.
I mean, I'd argued in my initial brief that those are it's not the most articulately written clause. And again, based on case law, the ambiguity is against the drafter of the contract, which was the appellee in this case. But that's not what the doctrine of handwritten terms control. Handwritten terms are when there are contradictory terms in a contract. For example, no pets allowed, and then there's a handwritten term, tenant may have cat, or maybe the name. Or sometimes there's an intent to, looks like it mark out a certain area of the contract, and then you have the handwritten terms. That's what the contract speaks to, not If the handwritten term said parcels must have the ability and it has nothing to do with feasibility study, or somehow incorporated that clause, but you can't just pick and choose what portion of the contract it's going to suddenly exempt when it's detrimental to your case.
No, you're fine. You're answering my question. And then looking at I'm going to jump to the final judgment. There was a specific finding from the trial court that basically says, and I want you to comment on that the trial court finds that the evidence presented at trial shows that the defendant knew of the deed restrictions on the property and chose not to disclose that. That implies to me that was a specific finding made as to not really fraud, but it's almost like something to the effect that it was intentional.
I mean, first of all, that sentence is not supported by the record and evidence. The record and evidence stated that he did a drawing and he used it by taking dimensions, and he believed based on the square footage of the property that the space would allow 16 lots, and he had a good faith basis for believing that. And the testimony in the record showed that he told Appellate, I've never submitted this plat plans to the county. That's the next step that needs to be taken. So the trial court's finding that he knew somehow that the county would not approve it is not based on any evidence that's in the record.
Let me see if I understand. I've been confused by this reference to the deed restrictions all along, because as I looked at the record, it seemed to me that it had something to do with the fact that you had to have a church on this property, and wasn't related to the number of lots that you could put on the property. Is that correct?
There was a deed restriction, and Appellate hired a title company to do a search, and that deed restriction was never revealed. But it turned out during the testimony in the trial that that's a moot issue because it was unenforceable and no one ever.
So what is the failure to disclose the deed restriction have to do with anything in this case?
Has nothing to do with it at all. What's at issue is that the appellee was only able to create 13 lots based on the residential zoning, not based on the spatial lay of the land, but based on the zoning of the land. That there's it's in there, I'm sorry, I don't have the mathematical calculation in my head, but there's a square footage that each lot has to be based on that zoning, not whether it could fit more spatially, and it had nothing to do with the church. And so when they went to the
evidence was, as I recall, that that wasn't being enforced.
Correct. The church wasn't enforced. And then what's a step further is that, there was no evidence presented in trial that the appellee ever did anything to try to have a density modification for the subject property. And that if he had exercised his rights under the contract, he would have contacted the planner and seen whether the property would fit 16 lots. If it didn't, based on the current zoning, whether he needed to apply for a density modification. And then we have a step further regarding the damages that the trial court awarded. In the contract, the written contract, there was never a value set on the specific lots, and there was never an actual value of the lots established at trial. A value or damages have to be established by substantive competent evidence, and value has to be actual. At trial, appellees testified to a range, $80,000 to $85,000, based on other lots in the area. We don't know what lots those were.
Well, let me ask you this. What's the measure of damages for selling? If you make a representation about property and it turns out not to be true, what's the measure of damages then, assuming there's liability?
Are you trying to
wouldn't it be the difference between what the value of the property as represented and what the value of the property was in fact?
That's one of the remedies, yes, and that was raised in my brief, but the court applied like a tort remedy or like a sales remedy.
But what evidence did you present about damages?
The testimony of the appellant was that comparable lots in the area were selling for $62,000, which is an $18,000 to $23,000 difference. And there was no evidence because they were arguing at trial that this was a contractual issue and that the buyer took the property as is, and therefore there was no damages.
But see, nobody brought in an appraiser to testify
Nobody
about
brought in-
the property and anything like that.
Correct, which is one of the errors regarding the damage award.
Well, I mean, if that evidence is not presented, what's the trial judge to do?
The trial court has to, he could have an evidentiary hearing on damages, say that I find in favor of this individual, now let's have a hearing on damages, or not award a
Did anybody ask for that?
No, because the trial court did not render a decision immediately. I think it came up like a month or two later in writing, and the entire judgment was what was before Your Honor and is included in the appellate record.
All right, you have 5 minutes left. You can continue or save them for rebuttal as you wish.
I'll have a seat, thank you.
All right.
Good morning, Your Honors. Fletcher Rush of Farquhar, Emmerich, Hackett & Carr on behalf of the appellee, Jack 1. I think it's most helpful to start from the beginning when appellant originally purchased the property in May of 2005. Appellant admitted that he purchased the property for the intention of subdividing the property, and then 3 months later listed the property, as you can see in the listing, which is in the appellate record, 2 separate listings. Each parcel may be divided into 8 lots, good for an investor along that line. Mr. Cornell, the real estate agent for Jack 1, saw the listing, contacted the appellant for more information. And it was at this time that the appellant faxed over an engineered drawing, which was based entirely on an assumption of the appellant that there could be 16 lots on the 2 parcels.
Is that drawing in our record?
Yes, Your Honor.
Do you know what page?
If you give me just a moment.
Sure.
I have to look back at my brief.
Rather than wasting more time, maybe you can find it later and tell us.
Okay, that would be fine. So the engineered drawing was faxed over to Mr. Cornell, or a real estate agent on behalf of Jack 1. And at some point after this, during the negotiations regarding the property, Jack 1 contacted the appellant for more information regarding the property. And it was at this time that the appellant represented to Jack 1 that the only thing that needed to be done in order to move forward with the property was to record the plat in the county records. So the contract at this point was anticipated by Jack 1. So they had Mr. Cornell, the representative, the real estate agent, began drawing the contract to make an offer on the property. The concern of Jack 1 and Mr. Cornell at this time was the divisibility of the property into 16 lots. So they made a point to include additional handwritten terms.
Okay, well, let me ask you this. Assuming that's a concern, and apparently it was important enough that it's handwritten into the contract, why would anyone pay close to $1 million for a piece of vacant land and not walk down to the zoning department and find out how many lots they could fit on the property before they close?
I can't speak to exactly why it was not done, Your Honor. I do know that with respect to Jack 1 and specifically Mr. Hamilton, it was his first time doing this type of transaction. He was not.
Doesn't that go to the issue of justifiable reliance?
Your Honor, yes, it does. And if I may speak to that briefly.
What's the impact of the fact that the trial court doesn't address that in the final judgment?
Well, if I may speak to justifiable reliance first. As I mentioned in my brief, justifiable reliance does not require that a buyer investigate information, or it does require that a buyer investigate information that a reasonable person would, but it does not require that the buyer, it does not mean that the buyer failed to exercise what you would consider due diligence. So I would submit to this court that based on the pattern of misrepresentations by the appellant, justifiable reliance would be exactly what the appellee Jack 1 did in this particular circumstance.
Okay, but there's no finding in the final judgment about whether there was justifiable reliance or not.
The trial judge found that the appellant breached the duty to disclose the deed restrictions and found that...
Okay, well,
yes, Your Honor.
did the deed restrictions have anything to do with this case?
I know of the deed restriction with respect to the church use, which you have mentioned already, Justice Wallace. My response to that would be that the church restriction also plays a part to this pattern of misrepresentation by the seller, the appellant.
Is there any evidence that the deed restriction about the church prevented the development of this property for residential purposes?
In fact, no, it was the contrary. The deed restriction did not,
Okay,
in
so
fact...
Why is that an issue?
Because it goes to the overall actions of the appellant in this case. It was a overall pattern of knowing non-disclosure and then an affirmative misrepresentation to the contrary by the appellant that led to the trial judge's finding of negligent misrepresentation.
Now could you answer my question about how we should take or address the fact that there's nothing in this final judgment that addresses the issue of justifiable reliance?
I would be just repeating what I've already said, Your Honor, that justifiable reliance does not mean a failure to exercise due diligence. And under these set of facts, based on the affirmative misrepresentations by the seller, and also based on the failure to disclose a known potential encumbrance on the property, that it was justifiable for JEC 1 to rely on the appellant's misrepresentations.
Okay, well, maybe let me try one more time. Maybe I'm not making myself clear. Justifiable reliance, I think, was something your side had to prove, but the trial judge didn't make a finding about that. So is that something we should be concerned about, or should we assume that there's a finding about that, or how does it play into our review of the issues that have been raised here?
Well, it's since the trial judge found both a breach of contract and a negligent misrepresentation, it's not required that you sitting in review of the trial judge's final judgment find that he actually was negligent in misrepresenting the status or character of the property. In fact, in my brief under the standard of review section, I believe in the fourth argument that I made, I disclosed that it is not required that the actual determination of the trial judge be in fact correct. It just means that some set of facts must support the finding of the final judgment of the trial. Does that help to answer your question, Your Honor?
I think so.
So if I may start with the breach of contract, the trial judge did clearly find that there was a breach of contract. As I mentioned, the real estate agent on behalf of JEC 1 specifically drafted additional handwritten terms which go to the heart of the issue of what we're appealing today, or what is the subject of this appeal today, that being the ability to divide the subject property into 16 lots. The contract itself, in fact, provides that handwritten terms shall prevail over any pre-printed or typewritten terms. And as opposing counsel has made clear, the feasibility study provision is a customary clause that is included in this type of FAR-bar vacant land contract. And it is a pre-printed term that provides a very general remedy or investigation period for the JEC 1 or a buyer in this instance, whereas the additional terms provide a specific remedy, the ability to divide the property into 16 lots based on representation of the seller.
But couldn't you see, because with that term saying parcels must have the ability to be subdivided, doesn't that kind of imply, not really imply, but it puts basically the parties, that was part of their agreement, that it must have the ability to be subdivided. Therefore, the feasibility study kicks in, check this land to make sure that it does have the ability to be subdivided. And if that fails, that would be a basis of not complying with the contract, that you could get out of this deal.
If I'm understanding you correctly, Your Honor, I agree. Noncompliance with the additional handwritten terms would be a separate breach than what's provided for under the feasibility study. It is Appellee's argument that the additional handwritten terms are a separate agreement that both parties entered into that are outside the scope of the feasibility study.
No, I guess the way I'm saying that would actually, there's an agreement that you're going to purchase this land. And part of that agreement is, we want to make sure that I'm able to subdivide this land. And that's where a lot of these feasibility, it gives you an option to investigate, to see. You have a 30-day period or whatever period of time. It's part of the contract to look into it, to see whether or not this complies. And it basically gives the parties an out, that if at the conclusion of whatever investigative period this doesn't comply, it gives me an opportunity to get out of the contract. Why wouldn't that be the case, as opposed to coming to your position that you could basically do nothing and rely on this and say, hey, it has to be done this way?
Yes, Your Honor. I think that if you looked at the particular facts leading up to the entering into this contract, there was, as I've mentioned, there was a pattern of misrepresentation by the seller. It began with the listing agreement. Not only did the appellant provide that the parcels would be able to be divided into a total of 16 lots, appellant also disclosed in the listing agreement that water, sewer, electrical were already in place, which is untrue. And in addition, as the trial court found, there was an encumbrance on the property, namely for church use only, that was knowingly not disclosed by the seller. So I think if you look at the particular facts...
What Judge Kuzan is asking is, why shouldn't we read the handwritten part of the contract in pari materia with the provisions for the feasible study, and the handwritten material becomes one of the things that if it's not true, then they can cancel the deal and get their deposit back and go look for some other property.
I think that would eliminate the need to put the additional handwritten terms in the contract at all. If you were to read it as only an extension of the feasibility study already provides for a 30-day period for someone to inspect and look to see if it meets with zoning requirements. As I've mentioned, Jack 1 and Mr. Hamilton were unfamiliar with the exact process of what was entailed of purchasing a large parcel of land and turning it into several lots. So it may have been, I can't speak to exactly what it was from, but it may have been due to the buyer's, Jack 1's inability or lack of knowledge as to the process. And he wanted to make sure that there was additional coverage so that in the event that something did happen with respect to subdividing the property, that it was specifically mentioned in the contract in language that he understood. But I can't speak to what the party's knowledge or intent was at the time of forming the contract outside of what's included exactly in those terms. The trial court also made a finding specifically that the appellant negligently misrepresented the character of the property. Opposing counsel has mentioned the Conklin case and also in the brief cited the Wasser case. Both of these cases are distinguishable from the facts that are before you today. In Wasser, the seller was found to be making a statement of opinion or mere puffing. The facts before you today show that what we have was an actual affirmative misrepresentation and a knowing non-disclosure by the seller of property. The trial judge found that it was this that the appellant had breached a duty to disclose known deed restrictions. And under the standard with respect to residential property, which I believe is the correct standard to apply, the seller does have a duty to disclose known defects and problems with the character of the property. The appellant has cited a real estate agent's commission statute in trying to define what in fact is residential real property. I think it's easier just to look to the actual terms of the contract. In the feasibility study itself, the purchaser, Jack 1, through their agent, specifically provided that the property would be for residential use and handwrote the term residential. And throughout the course of the trial, the testimony shows that the character of the property was in fact residential. Therefore, the correct standard to apply, as the trial court did...
I thought residential property meant property that had a house on it.
I think that's one definition, yes, Your Honor. I think that the intended use of the property is the best way to define it. If you went and purchased a vacant land with the intent of putting a house on it, I would submit that that is also residential property. You could look to the zoning of the property to determine what the character of the property is as well. This particular parcel was zoned 3.5 RSF, which is residential property zoning. But even under the lesser standard that applies to commercial property transactions, I would submit that the appellant also negligently misrepresented the character of the property. Appellant not merely sat back and allowed a buyer to make a knowing poor choice or lack of due diligence, whatever you would call it. Appellant took a step further and at every stage of the sale stepped in and made an affirmative misrepresentation to further coax the buyer into purchasing the property. I would like to speak to damages now, if there are no more questions about the negligent misrepresentation. Appellant has contended that the trial judge erred in not considering the comparable negligence of both parties. I would submit that the trial judge was not in error in not making an explicit finding of the percentages of negligence. It is not required of a trial judge to spell out the exact percentages of negligence of each party. And further, the trial judge found that the appellant both breached the contract and negligently misrepresented the character of the property. Excuse me.
What's the correct measure of damages in a case like this?
Well, under a theory of breach of contract, I think the benefit of the bargain would be due to the purchaser of the property. The purchaser, Jack 1, testified that he would not make a profit on the purchase of the property until he had sold between 11 and 13 lots.
Well, wouldn't if he was going to get benefit of the bargain damages, wouldn't that mean that he'd figure out what the property was worth at the time it was sold, and what it would have been worth if it had been as represented, and then subtract, and you come up with the benefit of the bargain?
Yes, Your Honor, that's one way.
Was any testimony like that presented?
The testimony of Mr. Cornell, a real estate agent, was in the record, which is on in your record on appeal. Mr. Cornell testified that the value of the property...
Did any appraisers come in and testify to the value of the property?
No, Your Honor.
Was there any evidence in the record about what the lots actually sold for once this property was developed?
This property was never developed. It was purchased in 2005 at a inflated price. As we are all familiar, the market for real property took a substantial decline in 2006 and 2007. The project was never developed and the lots were never sold. But while I'm on that line, I will say that Jack 1 did contact the appellant soon after purchasing the property once he realized that in pursuing the plat application that there were substantial difficulties and that there was no ability to divide the property into 16 lots. And it was at this time that Jack 1 had its agent, Mr. Cornell, contact appellant to disclose that there were substantial problems with what appellant had represented regarding the divisibility of the property. And I would like to talk on one other thing with respect to the trial judge's factual findings. As I've mentioned, the trial judge did find that the appellant breached a duty to disclose the deed restrictions. I would submit that the findings of the trial judge were enough to support
What deed restrictions are you talking about?
I'm only speaking as to the language of the final judgment. My assumption would be that that is the restriction as to church use only.
Okay, and weren't we in agreement that that wasn't an issue because they were unenforceable?
It was not an issue as to whether the property could ultimately be subdivided, but I would submit that it does go to the overall negligent representation.
If there was a title search done before the closing, wouldn't the deed restrictions have been disclosed in the title search?
They should, yes, Your Honor.
So if the deed restrictions made the property unacceptable to the buyer, they didn't have to close, did they?
No, there was no requirement.
So again, I ask you, what do the deed restrictions have to do with this?
Again, my statement is that it would be an overall pattern of misrepresentation by the seller. I was just trying to point out that the trial judge had found knowing non-disclosures by the appellant in this case, and that it would be Jack 1's position that that would also support a finding of something that amounted to an intentional non-disclosure or a fraudulent non-disclosure. And I believe that the questioning earlier of the of the appellant lended my discussion of that briefly. If there are no further questions, that's all I have for you. Thank you very
All
much.
right,
Thank you.
thank you. Ms. Cannell, you have 5 minutes left for rebuttal.
Thank you. I just want to briefly address the handwritten terms in incorporating with the feasibility study. Those terms were handwritten in the contract, and it would, again, be my position that they were to be read in conjunction with the feasibility study. The feasibility study portion of the contract is not a boilerplate term. It is an option that was specifically selected by Appellee's legal or real estate agent. It was meant so it would be narrowed down with their intended uses. It is very broad. It allowed the Appellee to do environmental tests, find out what the zoning restrictions were and the subdivision status. That's specifically what the feasibility study allowed, and he didn't do anything during that time. And as a consequence, he accepted the property as is. This was a commercial transaction. It was a commercial real estate. It's two broad pieces of land. The term residential had to do with he was going to replat the land and then make them into small lots where houses could be placed. He was a developer of land that engaged in a commercial transaction, did not perform his duties under the contract, and consequently, he took the property as is. Thank you.
All right, thank you both.